It starts with a contradiction so small it almost slips past you. A man walks into a courtroom to defend his truth. And then, under oath, he cannot remember what he himself asked for. Not a detail buried years ago. Not a footnote written by someone else. His own request. That's when the room changes. Before we continue, please hit the like button, subscribe to the channel, and turn on the notification bell for updates. Courtrooms are designed for discipline, for control, for order. They are not built for reaction. They are certainly not built for laughter. And yet, for a brief, almost disorienting moment inside London's High Court, something flickers across the benches. Not mockery exactly. Not cruelty. Something quieter. More damaging. Recognition. Because everyone in that room understands what just happened, even before the words settle. And once that recognition lands, it doesn't leave. This isn't about a headline. It isn't even about humiliation, at least not in the way the internet will later frame it. This is about something far more delicate and far more consequential. Credibility. Prince Harry did not come to court as a spectator. He came as a claimant. One of 7. A man who chose to testify, to sit in the witness box, to place his memory, his interpretation, and his emotional experience directly under legal scrutiny. And on the third day of that testimony, something subtle but irreversible occurred. He forgot. The question is not whether people forget things. Everyone does. Memory is porous. Emotion reshapes it. Time erodes it. But courts do not treat forgetting as a neutral human flaw. In court, forgetting becomes information. That's the part no one tells you before you raise your right hand. From the outside, this case has often been framed as familiar territory. A prince versus the press. A battle between a public figure and a tabloid machine. A continuation of a long, bruising war between the British media and the House of Windsor's most outspoken son. But step inside the courtroom and the story feels different. Quieter, sharper, more unforgiving. Because inside that room, no one is arguing about vibes or intent or how it felt to read a headline over breakfast. They are arguing about methods, about evidence, about whether unlawful practices were used to obtain information, about whether those practices can be proven, not emotionally, but procedurally. And that is where things begin to strain. Prince Harry's testimony is emotional. That much is undeniable. He speaks about the toll of tabloid scrutiny, about the relentless nature of coverage, about how it affected his wife, Meghan, about what he describes as misery, about fear, about feeling hunted. These are not throwaway claims. They are central to his narrative. They give moral gravity to the case. They explain why this fight matters to him beyond money or precedent. But here is the uncomfortable truth about courtrooms. Emotion does not substitute for accuracy. It doesn't cancel contradictions. It doesn't smooth over gaps. If anything, it sharpens them. When Harry struggles to recall his own request, something procedural, something basic, the moment lands not as tragic, but as destabilizing. Because the court is not measuring sincerity alone. It is measuring reliability. And reliability is built on specifics. You can almost sense the shift when it happens. The pacing of the questions changes. The air tightens. Counsel doesn't need to press. The moment already speaks for itself. This is the part of the story that rarely survives the retelling. Most viewers will later see clips. A headline. A line about laughter. A suggestion of embarrassment. But what gets lost is why that moment mattered legally, not just socially. Because forgetting your own request isn't funny in court. It's consequential. And yet, at the same time, the courtroom is listening to something else entirely. To Harry's voice when he speaks about Meghan. To the way his tone shifts when her name enters the testimony. To the emotion that remains steady even when the details wobble. That contrast, the emotional fluency paired with factual hesitation, is where the tension lives. It raises a question the court will never ask out loud, but everyone feels. Which version of this testimony should carry more weight? The pain, delivered with certainty? Or the details, delivered with uncertainty? This case sits at the intersection of those two things. On one side, a man insisting that unlawful media practices devastated his family's life. On the other, a legal process that demands precision, recollection, and consistency. And the two do not always move in sync. It's tempting to frame this as cruelty, as the system being too cold for human vulnerability. But that framing misses something important. Harry chose to be here. He didn't submit a statement and step back. He didn't allow his legal team to carry the burden alone. He placed himself in the witness box, knowing exactly what that entails. Knowing that every pause, every uncertainty, every contradiction would not be interpreted generously. Because courts are not designed to be generous. They are designed to be exact. That's why this moment, the forgotten request, lands with such force. It's not because it's dramatic. It's because it's ordinary. It's procedural. It's the kind of thing witnesses are expected to know without hesitation. And when they don't, the room notices. Not loudly, not theatrically, but in that subtle way professionals recognize vulnerability. The reaction that followed wasn't planned. It wasn't malicious. It was human, and that's what made it dangerous. Because once the court reacts, even briefly, the balance shifts. From that point forward, every answer is heard differently. Every emotional appeal is filtered through a new lens. Not disbelief exactly, but caution. This is where the public narrative and the legal reality begin to diverge. Outside the courtroom, people will argue about sympathy, about fairness, about whether anyone should expect perfect recall from someone recounting years of trauma. Those debates will be loud, polarized, emotional. Inside the courtroom, none of that matters. What matters is whether claims can be anchored to evidence, whether allegations can be supported by documents, whether memory aligns with records, whether testimony reinforces or undermines the case being made. And this is where the story becomes more complicated than a simple win-or-lose battle against the tabloids. Because the court is not evaluating whether Harry felt harmed. It is evaluating whether the alleged unlawful methods can be proven to have occurred in the way he suggests. And that evaluation depends on details. The irony is hard to miss. Harry has spent years criticizing the media for distorting facts, for prioritizing narrative over accuracy, for turning emotional moments into spectacle. And yet here, in a space that demands the opposite, he finds himself vulnerable to the same kind of distortion, not by headlines, but by the record. Every hesitation is recorded. Every uncertainty is noted. Every forgotten request becomes part of the file. This does not mean the case is lost, not even close, but it does mean the ground has shifted. And then there is Meghan. When Harry speaks about her, the room quiets in a different way. This is not legal argument. This is personal testimony. He describes her experience as one of misery. He speaks about the toll of media coverage on her mental health, on their sense of safety, on their life together. These are not abstract claims. They are framed as lived reality. And yet, even here, the court listens differently than the public might. It listens not for emotion alone, but for connection, for causation, for clarity. Did specific articles lead to specific harm? Did unlawful methods produce identifiable consequences? Can those links be demonstrated? The law does not operate on implication. It operates on proof. And that is where this case begins to feel fragile. Not because the pain isn't real, but because pain, by itself, is not evidence. This is the quiet truth at the heart of the courtroom that day. A truth that no headline can fully capture. A truth that explains why that moment of forgetting mattered so much more than it seemed. Because it wasn't about memory. It was about control. Control over narrative. Control over detail. Control over how the story is told when it can no longer be edited after the fact. For perhaps the first time in this long conflict with the press, Harry is not setting the terms. The court is. And courts do not move at the speed of outrage. They move at the speed of verification. As the day continues, that realization settles in. The questions keep coming. The answers keep flowing. But something has changed. The testimony is no longer just emotional. It is exposed. Exposed to contradiction. Exposed to scrutiny. Exposed to interpretation that Harry does not control. This is the cost of stepping into the witness box. It is also the risk. And the most unsettling part is this. The forgotten request may not even be the most damaging moment of the testimony. It may simply be the first crack. Because once the court senses vulnerability, it doesn't rush. It waits. And what it waits for, what it is listening for, will shape everything that follows. Did the courtroom realize it before he did? That's the unsettling question that hangs in the air as the next exchange begins. Because once a crack appears in testimony, it doesn't stay isolated. It spreads, quietly, methodically, through tone, through pacing, through the kinds of questions that follow. This is the moment where everything slows down. Not because the court wants to be dramatic. Courts don't do drama. They do patience. They do repetition. They do careful, almost surgical attention to what was just revealed, without ever saying so out loud. The witness box doesn't change. The judge doesn't react. The lawyers don't raise their voices. But the temperature shifts anyway. You can feel it in the rhythm of the questioning, the way the next question is framed, the way it circles rather than charges, the way it invites the witness to elaborate, not to defend. Because once a witness forgets something basic, the strategy changes. The goal is no longer to confront. It's to observe. And that's exactly what happens next. The questions move away from emotion and toward mechanics. Away from what it felt like and toward how it worked. Dates, requests, processes, who knew what and when, what was asked for and why. And suddenly, the testimony is no longer carried by momentum. It's carried by memory, or the absence of it. There's a misconception people have about courtroom questioning, that it's aggressive, adversarial, designed to break someone down. Sometimes it is. But often, the most effective approach is the opposite. Let the witness talk. Let them explain. Let the gaps reveal themselves. Because juries and judges don't need theatrics. They notice inconsistencies on their own. And in this case, the inconsistency isn't explosive. It's subtle, almost polite. That's what makes it dangerous. Harry answers, then clarifies, then qualifies. At one point, he seems to reconsider what he just said, as if realizing mid-sentence that the phrasing might matter more than intended. It does. This is the thing about legal testimony that catches people off guard. Every sentence becomes a commitment. Every word locks you into a version of events that can be revisited, compared, and tested. There is no rough draft in court. And yet, Harry is navigating this space as someone deeply familiar with telling his story, just not in this format. Outside the courtroom, he's been able to frame his experience emotionally. In interviews, in documentaries, in carefully structured narratives where context can be expanded, clarified, softened, where memory can be impressionistic. Here, memory is expected to be operational, and the court is beginning to test whether it is. The laughter, or whatever that moment was, has already done its work. No one mentions it. No one needs to. The shift is internal now. The room has recalibrated. The questions continue. They're not hostile. In fact, they're almost gentle. But they're precise. They ask Harry to link his emotional claims to specific actions, to show how the alleged unlawful methods connect to particular articles, particular consequences, particular harms. This is where the case lives or dies. Not in the broad claim that the press was intrusive, but in whether that intrusion can be proven to have crossed legal lines. And that proof depends on clarity. The problem is, clarity requires confidence in details. And details are where the testimony begins to wobble. Not collapse. Not implode. Just wobble. Harry is clearly invested. He wants to explain. He wants to make the court understand the weight of what he and his wife experienced. He speaks earnestly. At times, with visible frustration that the process feels so narrow compared to the scale of the harm he describes. But the court doesn't widen to meet emotion. Emotion has to narrow itself to fit the law. This tension becomes palpable. At one point, a question lands that seems straightforward on its face. A procedural clarification. A request to explain why a particular legal step was taken. Harry pauses. It's not a dramatic pause. It's the kind of pause people take when they are trying to retrieve something they thought they had ready. He answers, but the answer doesn't fully resolve the question. That's when the court does something interesting. It moves on. That might sound insignificant. It's not. When a court moves on without pressing, it's often because it doesn't need to. The answer has already been logged. The uncertainty noted. The inconsistency preserved for later. This is not a trial by ambush. It's a process of accumulation. Each small moment adds weight. From the outside, this can look unfair. Why should someone be penalized for not recalling every procedural detail in a complex legal battle? Isn't that what lawyers are for? That's a reasonable question. But here's the counterpoint the court operates on. If you are testifying about harm caused by unlawful actions, you must be able to articulate the basis of your claims with some precision, especially when those claims involve actions taken in your name. The court isn't asking Harry to be a lawyer. It's asking him to be a reliable narrator of his own case. And reliability, once questioned, is hard to restore. As the testimony unfolds, another contrast becomes impossible to ignore. When Harry speaks about Meghan, his language is fluid. The timeline might blur, but the emotional through line remains intact. He doesn't hesitate when describing the sense of being targeted, the pressure, the toll on her well-being. Those descriptions are consistent. They flow. But when the conversation turns back to process, to filings, to requests, to how the case was constructed, the fluency drops. This doesn't mean one side is true and the other isn't, but it does create an imbalance. And courts are exquisitely sensitive to imbalance. Because imbalance suggests selectivity. It raises the possibility, never stated outright, that some parts of the story are more rehearsed than others, more familiar, more emotionally anchored, while others exist at a remove, handled by advisors, lawyers, teams. Again, this is not unusual. Many claimants rely heavily on legal counsel. But when you choose to testify personally, that distance becomes visible. The witness box collapses hierarchy. It strips away buffers. Harry is no longer speaking through press releases or statements. He's speaking as himself. And himself is human. Human memory falters. Human emotion surges. Human narratives don't always align neatly with legal frameworks. The court knows this, but it cannot accommodate it beyond a certain point. This is where the story stops being about sympathy and starts being about standards. What standard of recollection is reasonable? What level of inconsistency undermines credibility? How much emotional testimony compensates for factual uncertainty, if at all? These are not philosophical questions. They are practical ones. They influence rulings. They shape judgments. And while the public debate rages elsewhere, inside the courtroom these questions are being weighed quietly, line by line. There's another layer here that complicates everything. Harry is not just any claimant. He carries symbolic weight whether he wants to or not. His presence alone raises the profile of the case. It invites scrutiny. It turns procedural moments into cultural ones. That means his mistakes, small as they may be, are magnified. If another claimant had forgotten a procedural request, would it have drawn the same attention? Possibly not. But Harry's testimony doesn't exist in a vacuum. It exists in a media ecosystem primed to react. Ironically, the very press he accuses of unlawful behavior is now watching his every word for signs of weakness. And weakness, once perceived, spreads faster than nuance. But inside the courtroom, the concern isn't optics. It's outcome. Will this testimony help establish unlawful conduct? Or will it muddy the waters? The court doesn't decide that in a single moment. It decides it over time, through patterns. And patterns are beginning to form. Nothing catastrophic. Nothing headline-worthy yet, but enough to shift how the testimony is being received. This is the danger zone of any legal narrative, the space where emotion and evidence begin to diverge. Harry continues. He answers what he can. He clarifies when prompted. He leans into the parts of the story he knows by heart. But the earlier moment, the forgotten request, has changed the frame. Every answer now exists in its shadow, not as a gotcha, as a reference point. And that reference point will matter later. Because testimony is not evaluated in isolation. It's evaluated in comparison to documents, to prior statements, to other witnesses. And those comparisons haven't even begun yet. The most important thing to understand about this phase of the case is that nothing is decided here. No gavel drops. No verdict looms. What happens instead is subtler. The court begins to map the terrain. It starts to understand where the testimony is solid and where it's vulnerable, where it aligns with the documentary record, and where it relies more heavily on interpretation. That mapping will guide everything that follows. And the person least able to influence that process now is the person in the witness box. Because once testimony is given, it belongs to the court, not to the witness, not to the lawyers, not to the public. It becomes a fixed point against which all future claims are measured. That's the risk Harry accepted when he chose to testify. And that risk is now unfolding in real time. The courtroom doesn't react again. There's no repeat of that earlier moment. No visible discomfort. No overt skepticism. But the damage, if that's the right word, is already done. Because from here on out, the questions will get narrower. The margin for error will shrink. And the room will listen not just to what is said, but to what isn't. And the most revealing parts of this case may not come from what Harry remembers, but from what he doesn't. This section is finished, and next, the court begins to examine something far more unforgiving than memory. Documents that don't forget, don't reinterpret, and don't care how anyone feels about them. If memory is fragile, paper is ruthless. That's the shift you feel as the court turns, almost imperceptibly, away from recollection and toward record. The questions stop orbiting how things felt and begin anchoring them. At one point, a discrepancy emerges, not a contradiction exactly, but a difference in emphasis. Something that sounded definitive in testimony appears more tentative on paper. A phrase that felt categorical out loud is qualified in writing. It's a small thing, the kind of thing that would be dismissed in conversation. But courts don't dismiss small things. They catalog them. Harry explains. He contextualizes. He suggests that the written language reflects legal caution, not personal belief. That the emotional reality exceeded what could be safely asserted in filings. This is a reasonable explanation. It may even be true, but it introduces a new complexity. If the documents were cautious because proof was uncertain, then how does the court weigh the certainty expressed now? This is the quiet dilemma unfolding in the room. Because the court isn't just comparing words. It's comparing confidence levels. Confidence then, confidence now, and asking which one deserves more weight. There's a moment, brief, almost invisible, where Harry seems to realize what's happening. That this isn't about catching him in a lie. It's about mapping evolution. How the story has changed, sharpened, intensified over time. That realization doesn't weaken his resolve. If anything, it hardens it. He leans into his lived experience. He reiterates the harm, the fear, the sense of being targeted. But the court keeps returning to the page. This is not cruelty. It's method. Documents don't accuse. They contextualize. They force specificity. When a question refers back to a filing made years earlier, it pulls the testimony backward. It asks the witness to occupy a past version of themselves, to remember not just what happened, but what they thought about what happened at the time. That's an uncomfortable place to stand. Because memory isn't static. It reorganizes itself around meaning, around outcome, around identity. Harry today is not Harry then, and the documents don't adjust for that. At another point, the court examines how certain allegations were framed, whether they were based on direct evidence, inference, or assumption. This matters legally. The threshold for unlawful conduct isn't met by suspicion alone. Harry acknowledges that some beliefs were formed by pattern recognition rather than direct proof. That repeated coverage suggested something deeper was happening behind the scenes. Again, this is understandable. Patterns do signal behavior. But courts require more than signals. They require substantiation. This is where the tension sharpens. Because the case rests not on whether Harry felt targeted, but on whether specific acts can be demonstrated to have violated the law. And demonstration lives in documents. Emails, invoices, records of payments, evidence of access that shouldn't have existed. These are the things the court is listening for now. Not loudly, patiently. The contrast between the emotional testimony and the documentary examination is stark. One is expansive. The other is restrictive. One invites empathy. The other invites scrutiny. And Harry is moving between them in real time. There's a risk here that's hard to articulate, but easy to feel. If the emotional narrative outruns the documentary support, the court doesn't reject the narrative outright. It simply stops relying on it. That's how credibility erodes. Not through collapse, but through quiet sidelining. At one point, a document is referenced that Harry doesn't recall drafting or reviewing in detail. He explains that his legal team handled much of the process, that he trusted their expertise. This is common. Many claimants operate this way. But again, the witness box changes the calculus. Because trust in advisors doesn't absolve responsibility for claims made in your name, especially when you're testifying to their accuracy. The court isn't unsympathetic. It understands delegation, but it also understands ownership. And ownership is what's being tested. As the document review continues, something else becomes clear. The case is more complex than the public narrative suggests. There are layers of allegation, some stronger than others, some supported by circumstantial evidence, some resting heavily on inference. Harry's testimony treats them as a unified experience, a continuous assault by the press. The documents, however, separate them into categories: claims, timelines, degrees of certainty. This separation matters because the court doesn't decide cases based on atmosphere. It decides them based on components. And some components are sturdier than others. The danger for Harry isn't that parts of the case are weak. Most complex cases have weak points. The danger is that the emotional force of his testimony may inadvertently blur distinctions the court needs to preserve. If everything is framed as equally unlawful, the court becomes skeptical of all of it. Precision is protection in law, and precision is hard to maintain when recounting years of sustained pressure. There's a moment, again, subtle, where the questioning pauses just long enough for the implications to settle. Not for the court, but for the witness. This is where the earlier forgotten request echoes back. Not as a joke, as a signal, a reminder that procedural clarity matters here. That details aren't accessories to the story, they are the story. Harry continues to answer. He doesn't retreat. He doesn't deflect. He engages. But the terrain has changed. This is no longer about telling the court what happened. It's about reconciling what was said, what was filed, and what can be proven. And reconciliation is a slow process. The court doesn't need to expose every inconsistency now. It only needs to note them. That's the unsettling part for any witness. You don't know which moments will matter later. You don't know which answers will be replayed against which documents in deliberation. You speak into a future you can't see, and that future belongs to the judge. As the document examination winds down, there's no dramatic resolution, no declaration that the testimony has been undermined, no visible reaction, but the shift is undeniable. From this point on, Harry's words will be weighed differently, not dismissed, but filtered. Filtered through paper, through prior assertions, through a legal framework that doesn't bend to narrative cohesion. This is the price of stepping out from behind statements and into sworn testimony. The court has what it needs now, not answers, but reference points. And those reference points will shape everything that comes next. Because soon, the focus won't be on what Harry believes happened. It will be on what the documents can, or cannot, support. This section is finished. And next, the press itself enters the courtroom in a way that shifts the balance again, turning observers into participants and scrutiny into something far more public than anyone anticipated. The press doesn't announce itself. It never does. It just becomes visible, not as a force, not as a character stepping into the room, but as a presence that subtly alters behavior, a slight stiffening of posture, a change in how sentences are shaped, a new awareness of how words might travel once they leave the witness box. Because the moment the press truly enters the courtroom, the case stops being contained, and that moment arrives quietly. Up until now, the dynamic has been relatively controlled. Lawyers ask, witness answers, the judge listens, documents speak. It's procedural, insular, almost clinical, but then the questions begin to reference coverage, not in the abstract, not as a backdrop, but as something active, something alive. Specific articles are mentioned, their dates, their tone, their reach, and suddenly the thing under examination is sitting in the room. This is the paradox of press litigation. The subject of the case is also one of its most attentive observers. Harry has accused the media of unlawful behavior. Now, the media is watching him attempt to prove it, word by word, hesitation by hesitation. You can feel the shift. The courtroom hasn't changed, but the atmosphere has. The stakes are no longer just legal. They're reputational, performative, even if no one wants to admit it. This is where cases like this get complicated, because the press doesn't just report outcomes. It frames moments. And framing is power. A pause can become uncertainty. A clarification can become contradiction. A moment of humanity can become weakness. Harry knows this. He's lived with it for years. But knowing something intellectually and experiencing it live, under oath, are two very different things. The questions begin to probe how coverage was perceived at the time, whether specific articles felt invasive because of their content or because of how they were obtained, whether the harm described stems from illegality or from intensity. This distinction matters more than it seems, because the law does not punish intensity. It punishes conduct, and conduct must be proven. Harry explains that the volume of coverage created a sense of siege, that the relentlessness itself felt unlawful, even when individual articles might not have crossed clear lines. This is an honest answer. It reflects lived experience, but it also reveals a tension at the heart of the case. If harm is cumulative, but illegality must be specific, how does the court bridge that gap? The press knows this question too. It's the question that has protected media organizations for decades. The distinction between aggressive reporting and unlawful intrusion. And as Harry speaks, the reporters in the room are listening for exactly that fault line. This is where tone becomes everything. Harry is careful. He doesn't accuse recklessly. He doesn't lash out. But he doesn't retreat either. He maintains that patterns indicate something more than coincidence. Patterns, signals, inferences. These are powerful tools in storytelling. They are weaker tools in court. The judge doesn't interrupt, doesn't challenge, doesn't correct. That silence is doing work, because the court is allowing the testimony to unfold naturally, without steering it away from its own implications. At one point, Harry references how certain stories seem to know things they shouldn't have known. Private details, information that felt inaccessible through legitimate means. This is the core of the allegation, the place where emotion and legality intersect. The court leans in. Not physically, but conceptually. This is the moment everyone has been waiting for. The question that follows is deceptively simple. How do you know? Not how did it feel? Not why did it hurt? How do you know the information was obtained unlawfully? Harry answers carefully. He talks about the improbability of access, about the repetition, about the sense that there had to be more than guesswork involved. Again, this is reasonable. It's intuitive. It makes sense. But intuition is not evidence. The press understands this. It's why they've survived so many legal challenges. Because suspicion, no matter how deeply felt, must be converted into proof. And proof is hard. This is where the dynamic becomes almost surreal. Harry is testifying against the press while the press watches him testify against them. They are both subject and audience, defendant and narrator. And that dual role changes how everything lands. You can feel Harry becoming more deliberate, not defensive exactly, but more aware. His sentences grow more precise. He avoids absolutes. He qualifies statements that earlier might have been left unqualified. This isn't weakness. It's adaptation. But adaptation itself becomes a story. The press doesn't need him to fail. It only needs him to be human. Because humanity is messy, and messiness is easy to frame. As the questioning continues, the court touches on how articles were responded to at the time, whether complaints were made, whether corrections were sought, whether legal action was considered immediately or later. These questions matter because they speak to contemporaneous belief. Did Harry believe, at the time, that unlawful methods had been used? Or did that belief crystallize later, as patterns accumulated and narratives solidified? The answer is nuanced. Harry acknowledges that some realizations came with hindsight, that certain things only made sense when viewed collectively, over time. This is a perfectly reasonable human response. But courts are wary of hindsight, because hindsight has a way of organizing chaos into coherence, of turning coincidence into conspiracy, of assigning intent where there may have been none. The court doesn't accuse Harry of this. It doesn't need to. It simply notes the timeline. And timelines matter. There's a moment, again, not dramatic, but telling, where the judge asks for clarification on whether certain allegations were based on information available at the time or on later disclosures from unrelated cases. This is a critical distinction. If beliefs were informed by later revelations about industry practices, that doesn't invalidate them. But it does complicate causation. Were the articles unlawful because they were unlawful, or because similar practices were later exposed elsewhere? The law cares deeply about that difference. Harry navigates this carefully. He doesn't overreach. He acknowledges complexity. He emphasizes that his concern is with patterns, not isolated incidents. But the press is already forming its narrative. Patterns can be framed as paranoia. Complexity can be framed as inconsistency. Caution can be framed as uncertainty. This is the cruel irony of the moment. Harry is doing exactly what a reasonable person should do in court, avoiding absolutes, acknowledging nuance, respecting process. And those very qualities can be weaponized outside the room. The court, of course, doesn't engage in that weaponization, but it can't control what happens once the words leave the room. This is where the case escapes its legal boundaries and becomes cultural again. Because the press doesn't just report what's said. It reports how it sounded. And how it sounded was careful. Careful is good in law. Careful is dangerous in headlines. As the session progresses, the questions begin to touch on motive. Not Harry's, but the media's. Why would a newspaper use unlawful methods? What incentive would it have? Harry suggests competition, exclusivity, the pressure to publish first. These are familiar arguments. They've been made before, sometimes successfully. But again, the court wants specificity. Which paper? Which article? Which method? Generalized claims don't carry the same weight. The press knows this. It has structured its defenses around this fragmentation for years. Separate each allegation. Isolate each claim. Demand proof for each instance. Harry's testimony, by contrast, is holistic. It speaks to experience as a whole. This mismatch is the central challenge of the case. As the questioning draws toward a pause, the atmosphere is heavier than before. Not because anything explosive has happened, but because the fault lines are now visible. The court has heard the emotion. It has examined the documents. It has observed the interaction between narrative and record. And now, it has watched the press watch back. Nothing has been decided, but something has been set in motion. Because from this point forward, every article written about this case will become part of the ecosystem the court is implicitly aware of. Not evidence, but context. And context, while officially irrelevant, has a way of seeping into perception. The judge doesn't comment on the press presence, doesn't caution, doesn't acknowledge. But the silence feels intentional, as if to say, this is what happens when stories and systems collide. Harry steps down at the end of the session looking composed, but altered. The testimony hasn't broken him, but it has changed the terrain he's standing on. The press files out too, already framing, already selecting, already shaping the version of events that will reach the public long before any ruling does. And here's the uncomfortable truth. From this moment on, the legal case and the public case will move in parallel, but not together. What helps one may hurt the other. What clarifies one may distort the other. Harry is now fighting on two fronts. And the most dangerous part? Only one of them follows rules. And next, the courtroom itself reacts. Not loudly, not overtly, but in a way that reveals far more than any headline ever could. Did anyone else notice the room change before the story did? Because this is the part that almost never makes it into print. Not because it isn't important, but because it's hard to describe without sounding subjective. And courts are allergic to subjectivity. Yet something unmistakable happens after the press becomes visible, after the documents are read, after the emotional testimony has been weighed against ink and dates and procedural memory. The courtroom reacts. Not with words, not with rulings, with posture. People sit differently. The pauses stretch just a fraction longer. The cadence of questioning tightens, not aggressively, but deliberately, as if the court is now listening with a different filter engaged. This is what seasoned observers recognize instantly and outsiders miss entirely. It's the moment when a case stops being exploratory and starts being evaluative. Up until now, the testimony has been received, considered, allowed to unfold. From this point forward, it will be tested. Quietly, relentlessly, and without warning. The judge says nothing to indicate this shift. Judges rarely do. Their authority isn't expressed through commentary. It's expressed through restraint, through what they choose not to react to, through what they let pass, and what they let linger. And what lingers now is doubt. Not disbelief, not dismissal, doubt. That's the most dangerous thing a witness can introduce unintentionally. Because doubt doesn't shout. It accumulates. The courtroom doesn't laugh again. There's no repeat of that earlier moment. If anything, the reaction now is more controlled, more contained. Professional. But professionalism doesn't mean neutrality. It means process. And the process has moved into a different phase. Questions that once felt open-ended begin to narrow. Instead of inviting explanation, they invite confirmation. Instead of asking why, they ask whether. Whether this was known. Whether that was assumed. Whether a conclusion was reached at the time or later. These are binary questions. And binary questions are traps for narratives built on complexity. Harry answers carefully. He avoids absolutes. He qualifies. He contextualizes. This is the right instinct. But it also creates a new tension. Because qualification sounds, to some ears, like retreat. The court doesn't interpret it that way. It understands nuance. But the court also understands consequence. Each qualified answer reduces the scope of certainty. Each careful phrasing limits how far the claim can stretch. This is where legal strength is won and lost, not in dramatic exchanges, but in inches. And the judge is watching those inches accumulate. There's a moment, small, easy to miss, when the judge glances down at notes for longer than before. Not writing furiously, not shaking a head, just reading. That, too, is a signal. Because judges write when something matters. And what matters now isn't how the story sounds. It's how it holds together. Harry's testimony has introduced several layers of belief. Some formed in real time. Some solidified later. Some influenced by broader revelations about media behavior that came years after the articles in question were published. None of that inva. The courtroom isn't cruel about it. It doesn't exploit it, but it registers it. This is where public narratives often diverge wildly from legal reality. Outside the room, supporters will see a man bravely recounting trauma. Critics will see a witness struggling with facts. Inside the room, the court sees something else entirely. It sees a claimant whose experience is genuine, but whose case must be evaluated on standards that don't bend for sincerity. That distinction is brutal, necessary, and deeply uncomfortable. There's a point where the questioning pauses, not for a break, but for a recalibration. Counsel confers briefly. The judge reviews notes. The witness waits. Silence like this is never empty. It's where decisions begin to take shape. Not final decisions, but frameworks. What weight to assign? Where to probe next? What to revisit later? Harry sits, composed but visibly aware that the terrain beneath him is no longer stable. This is no longer a forum where emotion leads and evidence follows. Evidence is now leading, and evidence is mercilessly indifferent to narrative coherence. The courtroom reaction, if you can call it that, is restraint sharpened into scrutiny, the kind that doesn't announce itself but leaves no room to maneuver. When questioning resumes, it does so with a different texture. Shorter questions, fewer invitations to expand, more emphasis on yes or no boundaries. These are not the questions of someone trying to understand your story. These are the questions of someone testing its limits. Harry answers within those limits. He doesn't overstep. He doesn't speculate. Again, this is good lawyering instinct, even when the witness isn't the lawyer. But it also means the testimony is becoming narrower. And narrow testimony carries less narrative force. The irony is striking. The more carefully Harry speaks, the less emotionally compelling the story becomes. The more emotionally compelling it becomes, the less legally precise it risks being. This is the impossible balance at the heart of the case. And the courtroom feels it. You can see it in the way the room holds its breath at certain answers. Not because they're shocking, but because they close doors. Doors that, once closed, can't be reopened later with documents or arguments. The judge notes something, pauses, moves on. Another signal. Nothing is said. Nothing is explained. But the trajectory is clear. This case is no longer about proving wrongdoing through testimony alone. It's about whether testimony can survive cross-referencing with material that exists independently of memory. Harry has done what he came to do. He has put his experience on the record. He has articulated harm. He has named fear and pressure and loss of safety. What he cannot do, and what the court will not allow, is let that experience substitute for proof. That realization is settling in. And here's the part no one likes to admit. The courtroom doesn't need to reject Harry's account to rule against him. It only needs to find it insufficiently supported. That's the quiet power of civil litigation. No villain, no hero, just thresholds. As the day draws toward its close, the reaction of the room is calm, professional, controlled. But the implications are anything but. Because once the court has shifted into evaluative mode, it doesn't shift back. Every subsequent witness will be heard in light of what's already been said. Every document will be read against this testimony. Every inconsistency will gain context. Harry's words now live in that ecosystem. And the most important thing is this. The courtroom has stopped listening for what happened. It is now listening for what can be proven. This section is finished. And next, the focus turns fully away from Harry himself and onto the legal machinery that will decide whether his experience translates into liability or dissolves under the weight of evidentiary standards no one in the room can soften. What happens when the story steps out of the witness box, but doesn't leave the room? Because that's the strange thing about what follows. Prince Harry's testimony may be over, but its gravity isn't. It lingers, not as spectacle, but as data, something to be processed, cross-referenced, stress-tested. This is the phase of the case that almost no one talks about, because it doesn't lend itself to drama. There's no voice shaking, no visible emotion, no headline-friendly exchanges, just machinery. Legal machinery is slow, unglamorous, and deeply consequential. And once it takes over, human narratives become inputs, not drivers. The court shifts gears. You can tell because the focus moves outward, away from the witness as a person, and toward the structure of the claims themselves. Away from what was said, and toward how the case is built to stand without saying anything at all. This is where lawsuits either find their footing or quietly begin to hollow out. The questions that now dominate are no longer about belief. They're about architecture. What exactly is being alleged? How many instances? Under which legal provisions? With what supporting material? These questions don't care who the claimant is. They don't care about his background, his trauma, his sincerity. They care about thresholds, and thresholds are unforgiving. Up to this point, Harry's presence has carried weight. His testimony has framed the case emotionally and morally. But now, that presence recedes, not in importance, but in influence. From here on, the case must speak for itself. This is where teams earn their fees. Lawyers begin mapping testimony against pleadings. They identify where Harry's account reinforces the case and where it complicates it. They isolate claims that are well supported from those that rely more heavily on inference. This is not about discrediting a witness. It's about triage, because not every claim needs to succeed for a case to matter. But some claims, if weak, can endanger the whole. The court is acutely aware of this balance. It doesn't need to decide whether Harry was harmed to decide whether unlawful methods were used. Those are related questions, but they are not the same. And the distinction is everything. The legal machinery hums quietly as schedules are adjusted, submissions anticipated, next steps outlined. This is where the rhythm of the case becomes procedural rather than performative. But don't mistake calm for comfort. This is often the most dangerous phase for a claimant. Because once the machinery takes over, emotion loses leverage. The court now asks, if we remove the witness entirely, does the case still stand? That's not cruelty. It's doctrine. Evidence must be capable of surviving independent scrutiny. Testimony supports it. It cannot replace it. This is where the earlier moments matter more than they seemed. The forgotten request. The qualified answers. The reliance on patterns rather than proof. None of these destroy a case on their own. But they shape how aggressively the court will demand corroboration. And demand it will. The legal team on the other side understands this well. They don't need to argue that Harry is lying. That would be crude. Unnecessary, counterproductive. All they need to show is that the case relies too heavily on subjective interpretation. That's enough. Because subjective interpretation is not actionable unless it's tethered to objective fact. This is the part that frustrates claimants the most. The feeling that the system is ignoring what matters most, the harm, because it can't see it clearly enough through the rules. But the rules are the system. And the system doesn't bend to fairness as people intuitively understand it. It bends to precedent. As the case machinery grinds forward, another reality becomes clear. Harry's testimony has now become a reference point for everything else. Every document submitted, every argument made, every inference drawn. If a claim aligns with his testimony, it gains narrative coherence. If it doesn't, it raises questions. This is why precision matters so much. A case can survive some inconsistency. It cannot survive systemic vagueness. The court doesn't say this aloud. It doesn't need to. The entire process is designed to surface it organically. And that's what's happening now. You can sense it in the way submissions are framed, in the way counsel begins to emphasize certain allegations over others, in the subtle narrowing of focus. This is not retreat. It's strategy, because smart legal teams know when to consolidate. The public may expect a sweeping reckoning of media behavior. The court expects something else entirely. A clear demonstration that specific actions, by specific actors, cross specific legal lines. Everything else is commentary. There's a moment, again, understated, when the judge signals interest in particular strands of the case. Not by saying so, but by asking follow-up questions that linger just a bit longer on certain issues. This is how judges communicate priorities. And those priorities matter. They tell you where the court believes liability might realistically be found, and where it likely won't. For Harry, this is a double-edged sword. On one hand, it means parts of his case may gain traction. On the other, it means other parts may quietly fall away. This selective survival is not personal. It's structural, but it can feel personal when your lived experience doesn't map neatly onto legal compartments. This is where the gap between justice and law becomes impossible to ignore. Justice, as people understand it, wants acknowledgement, validation, accountability. It wants the story to be heard in full. Law wants something narrower. It wants a violation that can be defined, proven, and remedied without opening floodgates it can't control. Harry's testimony sits uncomfortably between those two desires. It is expansive where the law is narrow, emotional where the law is procedural, holistic where the law is granular. None of that makes it wrong, but it makes it difficult. As the machinery continues, the court begins to prepare for what comes next: analysis, argument, and ultimately judgment. That judgment will not comment on Harry's pain in the way many expect. It will comment on conduct. And conduct, by its nature, is impersonal. This is the sobering reality of litigation that no amount of media training can soften. You don't win by being right. You win by being provable. The case now moves into a phase where language matters less than alignment, where every claim must be supported by something that exists outside the witness's mind. And here's the part that should make everyone uncomfortable. The public narrative may already be forming, opinions hardening, sides chosen, but the court doesn't care. It will take its time. It will weigh what it has, and it will decide based on standards that feel almost alien to the way these stories are usually consumed. Harry has done what he could do in the witness box. He has told his truth. He has placed it on the record. From here on out, his influence diminishes. The case will live or die on whether that truth can be translated into liability. And that translation is not guaranteed. This is the moment when many high-profile claimants realize something unsettling. Once you step into court, the story no longer belongs to you. It belongs to the process. And the process is indifferent to intention. As the legal machinery hums on, one thing becomes clear. Whatever the outcome, this case will not resolve the larger conflict Harry has with the press. It can't. Courts aren't designed to heal narratives. They're designed to resolve disputes. And disputes are narrow by necessity. The reckoning Harry seeks may be bigger than what the law can offer. That doesn't mean the case is meaningless. It means its meaning will be constrained. And those constraints are now closing in. This section is finished. And next, the consequences of that constraint begin to surface. Not in the courtroom, but in how the story starts to fracture publicly, revealing a widening gap between legal reality and the narrative many people think they're watching unfold. The courtroom doors close, but the story doesn't. Because now, the consequences begin to ripple outward. Not through rulings, not through judgments, but through perception. Through the subtle ways that narrative and law diverge once the room empties. Outside, the press has already begun its work. The cameras, the notebooks, the laptops, silent observers moments ago, become instruments of framing. Each sentence spoken in the witness box is filtered, condensed, and amplified. Some lines are taken as proof, some as contradiction. Some moments of hesitation are recast as uncertainty, some emotional flourishes as weakness. This is the ecosystem that high-profile litigation creates. The courtroom is the source, but the world interprets it through a lens that is anything but neutral. And the tension is immediate, because the public sees Harry, and they see what they expect to see: emotion, courage, moments of vulnerability. But they do not see the slow, surgical work of evidence parsing. They do not see how the judge, silently, has begun weighing confidence levels, consistency, and corroboration against cold documents. They see a narrative that looks continuous, but the law sees fragments. Inside the legal system, the testimony is already being mapped. Each paragraph of speech is compared against filings, emails, and records. Gaps are noted. Qualifications are recorded. Inferences are cataloged. This isn't about trust, it's about verification. And verification is meticulous, relentless, and indifferent to human suffering. Harry's emotional clarity contrasts sharply with the legal landscape he now occupies. Outside, it is compelling. Inside, it is supportive but insufficient on its own. Witnessing this tension is like watching two worlds overlap imperfectly, one driven by narrative resonance, one by evidentiary rigor. The challenge becomes obvious. What resonates as truth in the public sphere can exist independently from what counts as legally sufficient. And the misalignment is unforgiving. Already, social media buzzes. Clips circulate. Commentary erupts. Opinions solidify before the law has even finished its work. Headlines are framed to capture the most emotionally potent soundbites, not the procedural nuance that will determine liability. The trial, meant to be a slow, careful assessment, is being consumed as a high-drama spectacle. This is the peril of being both subject and observer. Harry cannot control the interpretation of his testimony once it leaves the room, nor can he predict which nuances will be amplified and which will be ignored. Every gesture, every pause, every qualifying phrase now has potential life beyond its intended purpose. And the courtroom machinery, for all its precision, is incapable of policing perception. Its decisions are confined to evidence, argument, and law. The court cannot legislate narrative. It cannot guard against headlines, clips, or public inference. For Harry, this dual reality is unavoidable. He has chosen to step into the arena, to testify personally rather than via affidavits alone. That choice brings visibility and influence, but it also carries exposure. His words, meant to clarify, can be reframed. His caution, meant to protect, can be construed as hesitancy. His careful navigation of nuance, meant to satisfy the court, can be portrayed as inconsistency. And so the consequences begin to diverge. Internally, the legal process progresses with deliberate pace. Teams pore over evidence, link testimony to filings, and identify points that require further support. They highlight strengths and vulnerabilities. Every note is an input into a machine designed to measure sufficiency, not narrative beauty. Externally, the narrative fractures. Clips of the forgotten request moments circulate widely. Observers debate what it means. Some frame it as human fallibility, others as incompetence. The irony is bitter. A moment that the courtroom recorded quietly as procedural vulnerability becomes a headline, a meme, a shorthand for doubt. This is the dissonance that high-profile litigants must navigate, the simultaneous worlds of law and story, overlapping yet fundamentally incompatible. The legal outcome may hinge on precision, documents, corroboration, and timing. The public outcome hinges on perception, emotion, and resonance. For Harry, the challenge is compounded by his position. Every word he has spoken, every pause, every emotional inflection carries magnified significance precisely because he is a public figure. His testimony is scrutinized not only for content, but for how it reflects on him personally, on the monarchy, and on the broader cultural narrative surrounding media accountability. And the subtle shift within the courtroom, the measured procedural response to his testimony, sets a tone that will persist through subsequent sessions. The court has absorbed what it needs: the evidence, the limits of memory, the emotional context. It has not passed judgment yet, but the framework for evaluation is now established. Meanwhile, outside, the ripple effect accelerates. Legal analysts dissect testimony in real time. Commentators interpret nuance as implication. Clips are replayed with selective emphasis, often divorced from the structural context of the proceedings. Audiences form opinions without understanding procedural thresholds. The emotional force of Harry's testimony becomes both a weapon and a shield. Compelling in narrative, insufficient in isolation. And in the center of it all sits the dual reality. The law is methodical, precise, and indifferent to public opinion. The story is immediate, chaotic, and unforgiving to nuance. From here on, every subsequent event will be viewed through this lens. Every document introduced, every subsequent witness, every legal argument will be interpreted not only in terms of its factual content, but in terms of how it interacts with the narrative the public has already begun to assemble. Harry's role has shifted. He is no longer solely the narrator of events. He is a participant in a dynamic ecosystem where testimony, press, public perception, and legal machinery intersect, often unpredictably. His influence on the narrative is significant, but not absolute. The tension now is structural rather than personal. The courtroom does not care about headlines. It cares about evidence. But the press, social media, and public discourse will treat the courtroom as if it exists for spectacle. This divergence is unavoidable and will have consequences that ripple through the remainder of the trial. And perhaps most disquieting. Even if the law finds a way to vindicate the claims, the public may interpret the same events differently. A procedural victory could be overshadowed by perceived weakness, hesitation, or error that has already been amplified outside the court. This is the paradox of high-profile litigation. Your credibility as a human being can be simultaneously strengthened and undermined by your own testimony. The legal system will assess sufficiency. The world will assess relatability, consistency, and impact. These assessments may align, but they rarely do perfectly. And so the case enters a new phase, one where the focus shifts from testimony itself to the machinery that will weigh, reconcile, and ultimately judge it, where evidence begins to dominate narrative, where precision matters more than emotion, where outcomes depend less on the resonance of lived experience than on the ability to anchor it firmly in verifiable fact. The courtroom may appear calm. Proceedings may continue without spectacle, but the internal dynamics are intensifying. The case is no longer only